One of the pervasive myths in New York City construction site accident litigation deals with workers' compensation. People think that if they are entitled to workers' compensation, or if they're already receiving workers' compensation benefits, then they cannot bring a lawsuit. And that's simply not true. It's especially not true in a construction accident standpoint. Generally, going away from construction accidents and just speaking generally, it is true that an employee cannot sue their employer if the employer has workers' compensation coverage for an on-the-job accident. So for example, if I have a slip and fall at Dunkin' Donuts and I work for Dunkin' Donuts, well, now I cannot sue Dunkin' Donuts, but I will get workers' compensation through Dunkin' Donuts' insurance carrier. And workers' compensation will give the injured worker lost wages paid, as well as medical bills paid. And they can go to an administrative judge and discuss it and basically have the payments either increased or decreased or modified. And then there's also something known as a Section 32 settlement that can happen at the end of the workers' compensation process. But with construction site accidents, it's entirely different. Now, if you are injured in a construction site accident, for example, if you fall from a ladder and fall, let's say, 4 or 5 feet from a ladder because of a defect in the ladder itself, or the way the ladder was placed, or maybe there was a little rock or piece of debris on the floor that caused the ladder to tip. Now, you also have been injured in a work-related accident. You also, as a construction worker, can receive workers' compensation benefits. You get your lost earnings, you get a workers' compensation lawyer, you go to a workers' compensation administrative hearing before a workers' compensation board judge, and the workers' compensation insurance carrier sends you checks periodically, so you receive that money. But now, because you fell on a construction site, the owner and the general contractor on that site are absolutely liable. They have a non-delegable duty to you, and they have absolute liability. So under the labor law, Section 240, also known as the scaffold law, you can bring a lawsuit against them, the owner and the GC, and you can recover in a third-party lawsuit. You can recover for pain and suffering. You can recover for lost wages that were not covered by workers' comp. You can recover for future lost wages, future medical expenses, past medical expenses not covered by workers' comp. Basically, you can recover for any economic damage not covered by workers' comp, and you can recover for your pain and suffering, which is the major monetary compensation that you will receive. So the fact that this myth is going around that your only remedy is workers' comp is simply untrue, and it should be debunked.